Welcome to everyone who is spending a little bit of their Tuesday afternoon with us. We appreciate you being here. In case you don't know me, my name is Adam Mastrolio. I'm an attorney in bonds, labor, and employment practice. I am based in our Syracuse office, and I'm going to be our host for today. Today is a special edition of the Tuesday webinar where we are going to attempt to prognosticate a little bit and look at how the change in administration may impact several areas that are very relevant to your businesses. We know that anytime there's a change in administration, there will be certain changes in policy goals, policy directives, and this election cycle is no different. So we're going to be taking a look at, if you could go to the agenda, Kathy, we're going to be taking a look at three different things. First, we're going to look at potential changes at the NLRB and how they may impact your business. Then we're going to look at immigration and transition, preparing for the post-election era, and that is keyed into immigration issues affecting employment specifically. And then finally, we're going to take a look at potential developments in employment law. And employment law, we are distinguishing from the NLRB because the NLRB represents a different area of employment law. It's actually labor law, but the two terms, labor and employment, are usually grouped together. We're going to separate them out today. So with that being said, let's get started. Here to talk to us about the NLRB is Jim McGrath. Jim is a partner in our labor and employment office in Manhattan. Jim has a ton of experience working on traditional labor issues involving collective bargaining, dealing with unions, the NLRB, and so Jim is the perfect person to give us an update or a preview from his perspective. So, Jim, I'm going to start us off with a question, and that question is, how quickly do we expect things to change at the NLRB?
My answer to that very simple question was going to be day one of the new administration, January 20th. But the most important date actually is going to be tomorrow. And I'll get into what that will mean. But let me first start with what's going to happen on January 20th. Next slide, Kathy, please. So what is going to happen? Well, day one, everyone expects, and I firmly believe, that President Trump will fire the general counsel, Jennifer Abruzzo, and also the deputy general counsel, who is actually Jessica Rutter. And I'll get into to Jessica's situation in a minute. Now, some of you may be asking, well, Jim, how do you know this? Do you have an inside line down in Washington? I do not, but I think there is a maxim in politics that turnabout is fair play. So what happened 4 years ago when President Biden came in? On the very first day, the day he was inaugurated, he asked for the resignation of the then general counsel, Peter Robb. Peter declined and was let go. The very next day, President Biden asked for the resignation of Alice Stock, the deputy general counsel. She too declined and was let go. Now, I'm happy to say both of them have since joined Bond Schoeneck and are members of our labor department, and we're glad to have them. So that will happen very much day one. And I think it's safe to say also that President Trump, being President Trump, will not even give them the option of resigning. I fully predict he will simply sack them unceremoniously and perhaps take some delight in that. As you all know, the general counsel, I should say, by the way, that when President Biden let Peter Robb go, that was the first time that had ever happened to a sitting general counsel not being allowed to finish out a term. So that is why everyone is confident in saying that President Trump will do this to Jennifer Abruzzo. So what does that mean? Let's go to the next slide if we can, Kathy. So the general counsel, Jennifer Abruzzo, has authored some, I believe there are over 20 general counsel memos. And what these are indications of how the NLRB will prosecute cases and how they're going to handle cases. Now, I'm not going to go through all 20 some odd general counsel memos, but it's fair to say that early on in the next administration, all, or certainly most of those general counsel memos will be rescinded. And that will have an immediate impact on how cases are litigated at the NLRB. So why don't we, next slide, Kathy, why don't we go through just a couple of these, 4 of these, and that is securing full remedies for victims of unlawful conduct. That certainly has a nice ring to it, but what the general counsel did over the last 4 years is to expand the remedies that the NLRB would seek in any unfair labor practice. And as a result of that, the money involved in these cases and the complexity of these cases increased dramatically. So the mantra at the NLRB has been full remedies for people who are victims of unfair labor practices. And why don't we go to the next slide as well? Again, another general counsel memo, and this is from earlier in 21, and it was the precursor to what is called the Thrive decision, named after the company, where both the NLRB general counsel and the NLRB itself went after a broader, much more deep set of remedies for victims of unfair labor practices, and went to something that is essentially consequential damages. Now, they avoided that term assiduously in the opinion. I believe they called it instead foreseeable damages, but that's really what they're doing, and that has some ramifications and is still subject to some litigation. Next slide, Kathy. Another big general counsel memo had to deal with monitoring of employees by employers. And I will say with this memo, there's what we would say on our side of the table, a cynicism on the part of the general counsel that all employer rules are somehow aimed at preventing what we call Section 7 activity, that is union activity. And as a result of that viewpoint, the general counsel said, well, we're going to challenge and seek to treat as unfair labor practices these monitoring of GPS, keyboard strokes, electronic monitoring in general. Now, if anyone has represented an employer or anyone with a fleet of vehicles knows, one thing you want to do is keep track of your vehicles. I actually had a case at the NLRB a few years back where we were able to win an unfair labor practice charge based upon the fact that the individual was taking a company truck, and every lunch he was outside of an adult establishment. And we were able to show in a matter of feet how far the truck was from this adult establishment. It had nothing to do with, by the way, Section 7 rights. It had to do simply with where's our truck and why isn't it being used to deliver goods. So that type of monitoring, which is ubiquitous in our workforce, was targeted by the general counsel, remains targeted by the general counsel, and I expect that to change very quickly. Next slide. And one more. Okay, there's nothing on this slide, but that's somewhat deliberate because the general counsel of the National Labor Relations Board has made a lot of press saying that she's going to target non-compete agreements, agreements that you all use to ensure that when an employee leaves you, they don't unfairly compete with you at their next employer. Now, the general counsel took a view that except in very limited circumstances, they're unlawful. Almost this across the board type notion that non-compete agreements, which have been around for many, many years, are inherently unlawful because they restrict movement of employees and have the impact of tamping down what could be protected speech. Again, I think most employers who use these things are not thinking about union activity. They're not geared to union activity. They're geared to whether or not someone is going to go to work for a competitor and use the information that they had with us unfairly against us with somebody who's right down the street. So that will change as well. Why don't we go to the next slide?
Jim, before you do, I just want to set something up here. So you've been talking about the general counsel and these memos that she put out. Now, we all agree that these memos are aggressive and employee friendly. She's trying to protect employee rights, or at least that's how it's been couched. So she, in all likelihood, will be replaced and those memos with her. But then the next step is, okay, well, that's the general counsel and her opinions. How is the board likely to change, if at all, with the change in administration?
Right. So I said at the outset that what's going to happen is actually going to happen tomorrow. And that's because tomorrow, as according to Senator McConnell, who I just listened to about half an hour ago, said that the vote on whether Lauren McFerrin, the chair of the NLRB, whether she will be reconfirmed for another term, that's going to come up tomorrow. And the Senate, which is split under remember, we're still under the prior Congress, is split 50-50. And if there's a tie, then Vice President Harris would cast the vote. So if you were looking at this, you would say, well, if McFerrin is not renominated, then there's going to be her vacancy plus one other vacancy. The board is comprised of 5 seats. So on January 20th, incoming President Trump would immediately have 2 vacancies that he could fill with his Senate majority and immediately have a 3-2 Republican board. But that all assumes that Chair McFerrin is not re-upped tomorrow. So I think there's going to be a lot of people watching this. And this is a little bit of This Week Inside Baseball, or if you're an MTV fan, this is Behind the Music as to what's going to happen and taking head counts as to how senators are going to vote on this. If McFerrin is re-upped, then the Democrats will continue to hold the majority through August of 26. Senator McConnell said that was, he may have used the word outrageous, but he was certainly urging his colleagues to vote against re-upping McFerrin. How that's going to play out, you can all do what I did today and watch C-SPAN tomorrow. Let me go on here to the next slide. So when Abruzzo came into office, she targeted dozens of cases where she wanted to see the law at the NLRB changed. She was quite successful in doing that. And there are many cases now that the pendulum has swung the other way, everyone expects these cases to be overturned. And you've seen some of these. The biggest one, the one that Chair McFerrin said was the most important, is the Cemex case. Why don't we go to the next slide, Kathy? Now, that case changed, about 75 years of NLRB law and flipped the way NLRB petitions are handled. That's a petition when a union says, we want to represent the employees of your establishment. They would make a demand for recognition. If the employer did not say yes, then the union would file a petition for recognition, and there would be a secret ballot vote. CEMEX turned the law on its head and said within 2 weeks of an employer receiving a demand for recognition and a representation by the union that it represents a majority of the employees, it's the employer's burden to file the petition. And it's really shrunk the time frame for employers to scramble and respond to requests for recognition by union. That, I think, will immediately be targeted by the new NLRB. Now, having said that, let me go back to Adam's question about how is this going to change? Even if President Trump gets a majority early on, it will still take years for the cases to work through the system so that these cases can be reversed by the NLRB and ultimately dealt with by the courts of appeals around the country. It will take years. If the Chair McFerrin is re-upped and this battle goes on, it's going to take even longer. So very much tomorrow's vote is critical to the new administration's agenda. Why don't we go to the next slide? So the other thing that the NLRB did was change the rule regarding handbooks. And the law on this has flip-flopped a few times over the years. And here we are. Under the old system, what is called the Boeing system, there were laws or policies that were deemed to be clearly lawful, some that required individual scrutiny, and others that were clearly unlawful. I will say, as someone who has looked at and revised handbooks for 30 some odd years, that standard was very helpful because there was guidance from the NLRB as to what you could put in the handbook and what you could not. The Stericycle case went back, though, and said, we're going to interpret handbooks that anything that had a reasonable tendency to chill employees' exercise of their rights, meaning their right to form a union. Well, almost inherently, a rule saying you can't do something could have, at some point, an impact on whether or not a union can come in or an employee can complain about it, all of that. So it's a very pro-union or pro-employee standard. I expect that to be targeted by the new board if we get a Republican dominated board. Next slide. And this one was literally just in the news. It came down just a few weeks ago. So-called captive audience meetings. These are meetings that employers hold when a union is trying to organize that employer. The employer will say, everybody please come to the lunchroom at 1 o'clock. We're going to talk about the union that has filed the petition. Well, General Counsel Abruzzo and now the NLRB has said that those mandatory meetings on work time are unlawful under the NLRA. Now, what they have said is you can still have voluntary meetings. You have to promise to employees that employees will not be subject to discipline if they don't go or if they leave early, and there won't be any adverse consequences. And the employer can't take records or attendance of who's there or who leaves asked to dip out early. So that is the rule right now on captive audiences. I will say, as a practical matter, many employers, and we often don't or advise employers not to make these meetings mandatory in the first place, to simply welcome employees, invite employees, but there's no reason why you have to mandate it. And if you do have to mandate it, that may be a bad sign for you in terms of the upcoming union vote. Next slide, Kathy.
But Jim, we're running a little low on time, but
Yep, yep.
I do think it's important to cover. We looked at what's going to happen with the general counsel. We looked at what might happen with the new board and how it will approach these cases. What about pending cases, pending litigation that's currently in front of the board?
Well, there's some really important cases that came out of the SEC, the Supreme Court case in Jarkissi, which is a SEC case, where the Supreme Court said that the judges there were improperly insulated from presidential review. And also there's an element of the Seventh Amendment. The Seventh Amendment to the Constitution says individuals, that includes corporations, have a right to a trial by jury in actions at common law. And the question is, are cases where there are these expanded remedies that the NLRB is now seeking, are those actions that are actions at law, or are they actions in equity? Legal damages in general are treated as legal relief, and that would entitle you to a jury. So these cases are winding their way through the courts, both as to the structure of the NLRB, can a sitting member be removed by the president? And then also this notion of a jury trial. Let me finish almost where I started, and that is this notion, or this prospect, I should say, that Member McFerrin may be re-upped. That could tee up something that has never happened, and that is a president trying to remove a sitting board member. There is legislation on the books that says NLRB members can only be removed for malfeasance. There may be one other category, but it's malfeasance. And the question would be, if President Trump and his advisors think that they don't want to be stuck with a Democratic majority until August, are they going to use this extreme option of actually firing a sitting board member? That would undoubtedly spawn years of litigation that only the Supreme Court could handle, and I do not prognosticate on those. So with that, Adam, I'll defer to my next to my colleagues.
Jim, thank you so much. As you can all see, there's a lot there, and there's a lot that we are anticipating will change. So we will certainly keep you updated on any new developments with webinars, blog posts, etc. So moving on, our next presentation is going to deal with immigration, but I want to clarify this is immigration in the employment context. We heard a lot about immigration during the campaign, but we're going to focus on the employment arena and how potential changes may impact that arena. To do so, we have one of my partners, Ksenia Primo. Ksenia is an attorney in our Syracuse office and handles a ton of immigration work. So Ksenia, welcome. It's great to have you, and thanks so much for being here. You are muted, Ksenia.
Sorry about that. Thank you, Adam, and thank you everybody for joining us today. As Adam said, today's topic, right, we're going to focus on immigration in the employment context. As you all know, immigration was such a hot topic during the election cycle, and it remains so. Can I have next slide, please? And unfortunately, at this point in time, there is a lot of speculation, but there is not really a lot of concrete that's coming from the incoming administration. There were, major pronouncements about deporting illegal immigrants and things of that nature, but we haven't really heard a lot in terms of what this administration intends to do when it comes to the employment-based immigration. Next slide, please. So what we can do at this point is to take a look at what has been done before under the Trump administration in terms of the employment-based immigration and expect more of the same. We definitely expect that the rules are going to be more stringently applied, that it's going to be more difficult to get certain approvals for work authorization. We certainly expect that there are going to be a lot more in terms of workforce enforcement sites, right? Visits by ICE to the employer's premises and making sure that everybody who is on site is authorized to work. We also expect that this administration is probably going to take a look at the prevailing wages that are applicable to when employers are sponsoring employees for H-1B visas. It happened during Trump's last administration. Employers were unpleasantly surprised when the new rules came out and the prevailing wages became unreasonably high, to the point where the employers were not able to file the H-1B petitions because nobody could afford to hire the foreign workers under these new rules. We were able to find some workarounds, such as using private wage surveys and things of that nature, and eventually the rules were overturned and did not become effective, but they did cause a little bit of pain for a period of time. So it is possible that we're going to see the same rules coming into play again, where the wages for the H-1B workers will be raised significantly, making it difficult to hire them. Next slide, please. We also expect to see the mandatory expansion for using the federal E-Verify system. And many of you are probably already familiar with this system. This is the system that the employers can use to verify their employees to make sure that they're employment authorized. Right now, it is not mandatory, except if you're a federal contractor or a subcontractor. At least in the New York State, the employers are not required to use it right now, but that may become mandatory on a federal level. We also expect modifications to the STEM OPT program. A lot of our clients utilize foreign students on STEM OPT to supplement their workforce. We may see some restrictions in terms of, how long the STEM OPT is going to be valid for and things of that nature. With respect to the H-1B petitions, it is possible that Trump administration will once again narrowly define what the specialty occupation means for purposes of filing the H-1B petition. They were very, very strict previously in terms of, evaluating the H-1B petitions. As some of you may know, in order to file the H-1B petition, the position must require a bachelor's degree in specialty occupation, and the person must have that degree. Where we have seen a lot of difficulty is that previously, when you file the H-1B petition and you say it is a position for industrial engineer, we will accept a bachelor's degree in engineering or industrial engineering or mechanical or systems engineering. Under Trump administration, we were getting a lot of RFEs, requests for evidence, asking us to justify how all of those degrees are related to one another. And if we cannot justify that they're related, then the H-1B petition would be denied. That was something new. The previous administrations were not taking that same read of the rules, but under Trump, we were getting a lot of RFEs, specifically with respect to whether or not the position for which the H-1B petition is filed constitutes a specialty occupation, even if we're talking about positions that historically we've never had issues with, such as engineers, accountants, professions of that nature. We're also expecting slower processing times, if that's even possible, because if you have foreign workers right now, that processing times are incredibly slow. But unfortunately, with the initiative to reduce the federal workforce, right, that's probably going to eliminate some of the adjudicator positions. And most likely, we're going to see even slower processing times, unfortunately. And as I mentioned before, we fully expect to be getting more requests for evidence. What does it mean for you? Unfortunately, it means that we will be bothering you for some additional information to beef up our petitions and supply additional information to the government. Next slide, please. Another restrictive requirements that we envision coming back is reinstatement of in-person interviews for employment-based applications. So Right now, it is not a requirement, and once we file the paperwork for a green card application, no interview required. Under Trump administration, that was eliminated, and every employment-based petition had to go through an in-person interview. Obviously, when you have an in-person interview, there are many more opportunities for denial because the adjudicator can be asking, the applicant questions face-to-face, look for inconsistencies and things of that nature. And obviously, another negative of reinstatement of this process is that, again, the approval process is going to slow down considerably because now you need to find adjudicators to interview the individuals in a timely manner, and that's definitely going to add to the processing times. Another thing that we anticipate seeing is the elimination of the USCIS deference policy. So what is the deference policy? So the deference policy says if the USCIS has approved the H-1B petition or any other immigrant petition in the past, and there are no changes to the terms and conditions of employment or any other significant changes, then the USCIS should defer to its prior adjudication and approve the petition again. So that's the deference policy, and it's been in place for decades. On the Trump administration, the deference policy was abolished, and the directive to the USCIS adjudicators was that they are to adjudicate each petition as if it were a new filing. So that's definitely not beneficial to the employers or the employees, and we unfortunately anticipate that that policy will be back in place. Next slide, please.
Ksenia, before
Sure.
you get to this, you can see where I'm going with my next question, which is there are a number of changes that you've outlined, but how can employers get ready for these changes?
Yeah, Adam, thanks for that question. I think one of the most important things that the employers can do right now, and I would highly recommend doing that, is to make sure that they have compliant I-9 policies in place. Certainly should take time to review the policies and, if necessary, to conduct internal audits to make sure that the employees that we have on our payrolls at this point in time are authorized to work for us. As I said, we anticipate that there is going to be an increase in site audits, right, where the ICE agent comes to your property and says, I'm from the government. I'm here to conduct an I-9 audit. I want to see your I-9 forms. And they will serve you with a subpoena, and you will have 3 days to produce the I-9 documents for anybody on your payroll at that point in time. If you get a subpoena, obviously you can, give us a call and we can help you with answering the subpoena. We can get you extension of time if you need an extension of time to get the documents. But it is definitely important to be prepared ahead of time for something like that. And so I strongly recommend reviewing the I-9 documentation, making sure that we've got a completed I-9 form for every employee hired after November 5th, 1986. And another important point is making sure that if we accepted documents, right, for the I-9 verification purposes that expire at a certain point in time, and that's mostly applicable to folks with employment authorization documents, folks on DACA status, TPS, things of that nature, make sure that we have re-verified those folks before their documents expired. And obviously, if our I-9 doesn't reflect that they have been re-verified, then we need to do so immediately. And we need to make sure that individuals who are completing the I-9 forms on our behalf have been properly trained and know what they're doing. The I-9 form looks very simple, but there are many, many opportunities for making mistakes on that form. And if somebody doesn't have an appropriate training, it's very easy to miss things or do them incorrectly and cause pretty significant problems for the employer. Next slide, please. That's another thing that we frequently see. The Form I-9 is periodically updated, and sometimes clients continue to use an outdated form. So just make sure that you're using the most current version of the I-9 form. If you are using E-Verify, making sure that we are completing cases in E-Verify within 3 business days, like we have to do that. So just making sure that we are doing it in a timely manner. Next slide, please. All right, so another big area of where we should check for compliance. If you are employing H-1B workers, make sure that your public access files are in order. Because again, that's where I suspect going to see enforcement actions taking place, right? And I don't know how many of you had an experience of an ICE agent coming to your premises and asking you questions about your H-1B employees. But typically what they want to see, they want to see the public access file for the H-1B worker. Next slide, please. And the public access file must contain certain documentation in it. It has to have a signed copy of the certified labor condition application. It has to have documentation of the employee's exact pay rate. We need to have documentation in terms of how that pay rate was set. Also need to have documentation showing that we've properly notified our workforce regarding hiring of the H-1B worker. Public access file needs to have information about benefits offered to the foreign worker, and also documentation that a copy of the labor condition application was actually provided to the foreign worker. It is a lot of documentation that needs to be maintained in a public access file. And unfortunately, I see it very frequently that the employers are not maintaining that information. The public access file, if you used an attorney to prepare the H-1B petition, your attorney should have provided you a copy of the public access file, and that needs to be maintained on premises, and it needs to be easily accessible to you in case there is an audit. Next slide, please. Another recommendation I have is to identify an employer representative who will be responsible for dealing with government agents if they come on your premises to conduct an audit. So that's important. So we need to know who that person is. They need to be prepared to deal with the agents, and they need to have the contact information for the attorney available as well in case questions come up that require legal assistance. In terms of, again, if you've got, employees on work visas, you may want to, and those employees are coming up for extensions, you may want to file extensions as soon as possible to ensure the adjudication under current rules and not the rules that potentially will go in effect later down the road. So I would suggest looking at your cases and identifying those that are expiring within the next 6 months, and then if necessary, filing for those extensions via premium processing, just especially if you have cases that are somewhat risky or they are not clearly approvable. I would definitely recommend doing premium processing for those cases under current rules. Another thing that I wanted to mention, you're probably going to be getting a lot of questions from your employees regarding whether they should travel. And it's a gray area. I'm sure there are attorneys out there saying that you should not travel under any circumstances. I think that's unrealistic for many of your employees, because you're really telling them you're not traveling over the next 4 years. I just think that's it's not doable for many folks. So the advice that we give is, if you're making sure, they need to make sure that their passport is valid for quite some time. Because if the passport is not, expires within 3 or 4 months, they're going to be admitted only through the date of the expiration of their passport, and that's not going to be good for them. But as long as their travel documents in order, if they have their H-1B visa stamp, if they have their passport, if they have their approval notice and employment verification letter from you, most likely it's okay for them to travel. Like, I would discourage unnecessary travel, but if they're traveling for work or something like that, I do not recommend barring employees from travel going forward. It can be done. Obviously, we need to plan for it carefully, and feel free to consult your immigration attorney regarding what type of documents they will need to carry to make sure that they do not have any issues returning to the United States. Thank you very much. That's all I have for today.
Thank you, Ksenia. Appreciate that. All right. Last but certainly not least is my partner in our Rochester office, Kate McClung. Kate is a very experienced employment litigator, and she has an update for us on some potential changes or developments related to employment law specifically.
Thanks, Adam. If you could go to the next slide, please, Kathy. So you can tell there's a lot of changes anticipated. We're going to run over. I'm going to keep going and finish this whole section. If you can't stay today, you will get the recording by email, and it's also on the website. So starting with USDOL, we've seen a lot more back and forth on what the rules are with the DOL. It's becoming more and more like the NLRB in that regard. So some examples, one is the salary levels for exemptions. The Obama DOL issued a final rule to increase the white collar exemption threshold to take effect December 1st, 2016. A federal judge blocked that rule at the last minute. The Obama DOL filed an appeal before Trump's inauguration, but when Trump came into office, his Department of Labor dropped the appeal and rescinded the rule. He then issued a new rule a couple of years later, increasing the white collar exemption salary requirements, which are in the first parentheses, as well as the salary level for the highly compensated employee exemption, which is in the second pair of parentheses. Next slide, please. So we're now kind of facing, it's a little bit deja vu. Fast forward to 2014, Biden DOL has issued a final rule that took effect July 1st of this year, and also had a second round of increases, which were slated to take effect on January 1st of next year. You can see the amounts there, both the white collar exemption amounts and the amount for the highly compensated employee exemption. A federal judge vacated this rule in November, and now the Biden Department of Labor has filed the notice of appeal, but it's expected that the exact same thing is going to happen as what happened in 2017, and the Trump administration is going to decline to pursue that appeal, rescind the rule. Because of the federal judge's decision, it's not currently in effect, so we are back to the 2019 salary levels. Next slide, please. It's important to keep in mind this is for federal law only. For all of these issues, you also have to comply with any applicable state laws. And New York State, as you know, has quite a few employment laws itself. New York State has salary levels, its own salary levels, which are much higher than the federal level for both administrative and executive exemption. New York does not have a minimum salary level for professional exemption, though. So there, the federal salary level becomes very important. Another thing, yep.
Kate, sorry to interrupt, but just so that these are the questions I usually get. You know, why do I care about the federal threshold if I'm a New York employer? With respect to the executive and administrative exceptions, you know, you'd have to make sure that you're satisfying the New York rule.
Yeah, that's correct. That's correct. And the proposed increases under Biden, that second round of increase got pretty close to some of the New York salary levels, and could have potentially made a difference because there's certain things that count towards one salary level but don't count towards the other. So for example, New York State lets employers count boarding, lodging, and other allowances towards that salary level, but federal does not. So there are different calculations for the two. Because of the timing of all of this, a lot of employers made that first round of changes on July 1st. They either increased employees' salaries to that new salary level, or they reclassified them as non-exempt. And so all of those employers are now grappling with, what do we do now? Do we revoke those changes going forward? Do we keep them, but maybe not do increases next year? So, you know, that's a business decision that a lot of companies are having to make right now. Next slide. Another similar back and forth we've seen with the DOL is the independent contractor standard. So on July 1st of 2021, just a few weeks before he left office, the Trump Department of Labor issued a final rule to change that standard, which was set to take effect on March 8th, 2021. The new standard didn't use the balance, all of the factors weren't given the same weight under the new standard. More weight was afforded to how much control the company had over the worker and the worker's opportunity for profit and loss. Those became core factors to consider, and the rest of the factors would be considered but given less weight. It was viewed as a more employer-friendly rule because it was a much broader definition of independent contractor. So Biden takes office a few weeks later. In March, early March 2021, the DOL issued a final rule delaying the effective date until May 7th, and then issued a final rule withdrawing that Trump rule altogether. Next slide. Then in March 2022, a federal court vacated both of Biden's final rules, which both delayed and withdrew Trump's rules. The court cited procedural legal defects. And the court specifically held that Trump's final rule became effective on its initial effective date back in March 8th, 2021. And this is an important point to keep in mind with the back and forth. You know, if a court vacates a rule, they may say it's been in effect this whole time, and you may not have been complying this whole time. Or if the new administration comes in and rescinds a rule, you know, you have to think about, was it ever in effect? In October 2022, the Biden DOL released a proposed rule which would rescind the Trump rule and change the independent contractor standard back to the economic realities test. And in January, Biden issued a final rule effective March 11th, 2024. So you can see again, back and forth, depending on who's in the White House. This one took a while for the Biden administration to finally get rescinded and issue their own rule. But we do expect that the Trump administration is going to promptly take efforts to change the standard back. Next slide. The joint employer rule, we've also seen back and forth. So in January 2016, I think the day of Trump's inauguration, Obama's DOL issued guidance broadening the FLSA standard for joint employers. Trump takes office later that day on June 7th. So about 5 months later, he withdraws the guidance. And then in January of 2020, his DOL issued a final rule changing the joint employer standard in a much more employer-friendly way. And that had an effective date of March 16th, 2020. In September, a federal court struck down significant portions of the rule. And when Biden took office, his Department of Labor rescinded the rule. They didn't provide a new rule, and they still haven't to date. But the Trump administration is expected to revisit this issue. It's possible. We've seen in the last few slides a lot of activity in January, right before an inauguration. So it's possible the Biden administration is busily working at this very moment on their new joint employer rule. So stay tuned. Next slide. Okay, we've also seen a lot of back and forth with minimum wage for federal contractors. Obama signed an executive order back in 2014, setting a minimum wage of $10.10 for certain federal contractors with potential future increases, effective at the start of 2015. In 2018, Trump signed his own executive order. He didn't rescind Obama's entire order. He just exempted certain seasonal recreational employees from that minimum wage requirement. When Biden took office, he signed his own executive order, increasing the minimum wage for certain federal contractors to $15 an hour, starting at the beginning of 2022, with potential subsequent increases. And he did revoke Trump's executive order, so there's no longer an exemption for the seasonal recreational employers. Next slide. There have been multiple legal challenges all across the country on Biden's executive order. There's currently a circuit split among the federal appeals courts on that issue, whether it was lawful or not, and a petition for cert to the Supreme Court is currently pending. The Supreme Court may take this issue on. They look for cases where there is a circuit split on important issues, and that's certainly true here. The Trump Department of Labor, though, may revoke the executive order coming into office. They may decline to defend it in court, stop pursuing the litigation that's unfavorable to the Biden rule. They may reinstate his executive order with that special exemption for seasonal recreational employees, or he may issue a new executive order with brand new limitations on minimum wage requirements for federal contractors. So there's a lot of different ways Trump could go with this particular issue. Next slide. There's a lot of other potential actions that we think Trump might take with respect to wage and hour laws. So some think he may create some sort of comp time alternative to overtime for all employers, including public sector. Right now, this is purely a private sector option for certain public sector employers. But this would permit, if this was implemented, it could potentially permit private sector employers to give time off in lieu of overtime. So that's a possibility. They may reinstate the payroll audit independent determination program. This is something that they put into effect in Trump's first administration, and then it was shut down during Biden's administration. This was a program that permitted employers to self-report minimum wage and overtime violations, calculate what was due going back 2 years, and the Department of Labor would agree that they would just limit it to 2 years. They wouldn't seek the third year, because under federal law, it can go back 3 years. They wouldn't seek liquidated damages, which is a 100% penalty paid to the employee, and they wouldn't seek civil penalties, which are penalties that go to the federal government. The DOL under Trump definitely was very vocal in touting the success of this program, so I would be very surprised if they don't reinstate it. Another thing is removing or reducing taxation on tips. There's been a lot of discussions on this in both sides of the aisle. There's currently both Democrat and Republican legislation pending on this issue. The main difference is the Republicans don't think that the tax credit should be eliminated. It should purely be about income tax on the tips themselves, whereas the Democrats want to eliminate the tax credit and say all employers have to pay at least minimum wage. Another very wide category is US DOL opinion letters. Trump used these a lot to provide new guidance, explain rules in new directions. Obama didn't issue any. Trump issued 72, including 9 in the 2 weeks before his inauguration. And Biden has only issued 1. So you can definitely see a difference in practice there. But Trump, first time around, used this a lot. There's a good chance he will the second time too. Next slide. Okay, so that was wage and hour. The EEOC, we don't see as much back and forth depending on who's in the White House historically with the EEOC, but we certainly see changes in priorities. So the way that this one works is the Trump administration probably won't have a Democratic majority until July of 2016. There's currently 3 Democrat commissioners, and the first one whose term is expiring is July of 2016. There's 1 Republican commissioner and there's 1 vacant seat, which I'm sure Trump will fill. That he is likely to replace the general counsel quickly, similar to the NLRB. The Trump EEOC, once he gets that Republican majority, could shift the agency's focus a lot of different ways. Over the last few years, we've had the Pregnant Workers Fairness Act and regulations came out earlier this year. We may see this new EEOC in a few years start limiting the scope of that, of those protections, especially with respect to abortion issues. They may roll back protections for LGBTQIA workers or scale back diversity, equity, and inclusion initiatives. That's something that the Trump administration, we saw them do both of those things during the first administration. I think it was their first day in the White House, they removed all references to LGBTQIA+ from the White House website. They may reduce the EEOC's data collection efforts, which probably some of you are very glad to hear because that can be quite onerous on employers. They may pursue charges against employers who offer pro-abortion benefits, such as a travel benefit to travel out of state to get an abortion. The current Republican commissioner has said that that's discriminatory against pregnant women who decide to continue with their pregnancy. They may go after policies perceived to be anti-religion as well. They may shift resources from litigation to compliance and revisit changes to the conciliation process, which they tried to do the first time around, but that was not ultimately successful. Next slide. With respect to restrictive covenants, we saw the FTC announce a final rule banning a lot of post-employment non-compete clauses, and they define non-compete pretty broadly, so it would have covered some non-solicits and confidentiality agreements as well, not all of them, but a federal court did strike that rule down. The Biden FTC has filed a notice of appeal, but we expect Trump will abandon that appeal or withdraw the final rule. Next slide. So I mentioned DEI earlier with the EEOC. This also comes up with executive orders. So Trump had issued an executive order prohibiting federal contractors from providing certain diversity training or discussing divisive topics in workplace trainings. That has been rescinded by Biden, but he's likely to reinstate it. He may revoke various Biden executive orders on these issues as well. Biden issued a number of them. Some are speculating that he may even revoke Executive Order 11246, which requires federal contractors to recruit women minorities and have certain affirmative action plans. This was an executive order from Lyndon Johnson, so it's been in effect for quite a while. Next slide. With respect to OSHA, the Trump administration may delay or withdraw proposed standards, soften current standards on airborne respiratory viruses such as COVID, reduce inspections, especially in low-risk industries. One thing they did in the first time around is when compliance officers left, they didn't replace them consistently. So we expect to see that again. They may take the same approach with vacancies on the OSH Review Commission. And again, here, as with many of these agencies, we expect to see more of a focus on helping employers comply with the law and less on penalizing employers through enforcement efforts when they don't comply with the law. Next slide. And finally, one thing we saw in Trump's first administration with respect to employment laws is his daughter Ivanka was very vocally in favor of paid leave. Trump did extend the 12-week paid family leave to employees of federal agencies and contractors. We've heard on both sides of the aisle growing support for some form of family-friendly policies. Trump has been a lot more quiet during the most recent campaign on this issue. If there is a lot of support for it, he may get behind it, but it may be more likely some sort of increased child tax credit or tax credits for businesses for providing paid leave instead of a paid leave program requiring private sector employers to provide paid leave when family health issues arise. Okay, so that is everything I have, Adam. Thanks, everyone.
Kate, thank you so much, and thank you to everyone for being with us. Remember that our slides are always available in the next couple of days on the Bond Schoeneck King website. Also, don't forget to register for our blog so you get email updates whenever we submit or publish information memos or blog posts regarding these changes. Thank you all for being with us, and we will see you again next week.